Welcome all, ladies and gentlemen, and lovely to see you all here. This session is very topical for, I think, two reasons. One is that we heard from our opening guest speakers this morning the question and role and infrastructure of arbitration in India is a moving feast, and something that, according to what we heard this morning, needs some considerable improvement on in a number of aspects. And so part of what we're going to be talking about today from both the legal and the internal perspective is what arbitration has offered Indian business and what it involves in terms of the Indian business and legal community. The other most interesting question, which I don't think is really being addressed at all in any coordinated way by arbitral bodies, let alone parties and lawyers, is how you respond to allegations of crime or criminal conduct which emerge during an arbitral process. What does it mean for you as a party? What does it mean for you as a lawyer? What does it mean, for example, if the state, or if you're in a state investor arbitration and a party is a state, what should the state do? What issues of public policy might arise in terms of investigating, looking at and deciding whether to prosecute as a matter of good policy parties who engage in crime or who are alleged to engage in crime? Are parties who are states using the question of alleged criminality as a negotiating tool in an arbitration, in private, to essentially extract a better deal? Or is the whole thing just so too hard that it's really left to individual arbitrators or a tribunal body to decide what to do within the parameters of the arbitration, and nothing emerges in the public arena in terms of the allegations of impropriety or criminality? And so this is an issue that's really interested the International Bar Association, that's set up a working group across committees involving arbitrators, lawyers, criminal lawyers, civil lawyers, to look at this question of what is going on within the arbitral space. How should arbitral bodies respond? Should there be a more global move amongst bodies to regulate these sorts of issues, or provide advice or provide guidance? Or is it all too hard and needs to be left to individual arbitrators because the conduct itself is so individual to particular cases? If that's the case, then what do you all do when, for whatever reason, tactical or otherwise, somebody with a badge, a warrant and or a gun turns up and says, I want everything that I'm entitled to, documents, witnesses, information, and they're entitled to take it? What then happens to the arbitration? The private, discrete nature of your dispute has the potential to become very public and very unpredictable, because state agencies and crime bodies will go ahead and investigate and make decisions on their own accord, not in accord with any process of arbitration. So with that sort of background in mind in terms of some of the topics we're going to look at, I'd like to turn first, if I may, to Prasanna, who's had many years of experience both as a general counsel and in the arbitral process itself, to give his views about arbitration for business from an Indian perspective and what it means and some of the issues that he thinks is important for Indian business and arbitrators in India to be aware of. Prasanna.
Thank you. Thank you. As a general counsel, who can be now called business enabler, because you're no longer a pure law stater or a person who simply gives advice. You are actually supposed to devise and implement. The first thing that we actually learned in the process of evolving as GCs is to address the question whether an arbitration clause is a boilerplate clause, or is it something which actually an enforcement mechanism. The more you look at an arbitration clause as an enforcement mechanism, it actually helps you to decide the next question, whether to arbitrate or to litigate. Should everyone have arbitration clause just for the heck of it, or should one make an evaluation and see where you need to have the liberty of having an arbitral process commencing at some other point in time, but keep litigation open? There have been companies where I have worked where people have said, let's keep silent on arbitration. Let litigation be the obvious choice. But when disputes actually come to a head, we can always talk to the other side and drive sense into his mind and make him agree to an arbitration agreement. But if I choose arbitration, the doors of the court are closed, and I lose the right of appeal and a number of other benefits that I might have. So it's extremely important for people who are advising companies to look at arbitration as part of the dispute resolution policy of the organization. That's an extremely important aspect of it. Having said that, I do believe that arbitration is perhaps the most preferred route. It inspires confidence in the counterparty who is dealing with us that we are not going to drag him to court. At the same time, we are also making sure the other party doesn't pull the plug and then take us to court. Arbitration is also, for us in an international context, a kind of a neutralizer of a home turf advantage. You always have this tussle that a contract is governed by laws of New York, laws of London, or whichever other foreign country. And that may be a governing law where there may not be much scope for negotiation, particularly if you are having some kind of a dependency on that person to carry out a particular project. So the neutral option is to locate arbitration either in Singapore or Paris and put a distance between both the parties and the arbitral venue so that everybody thinks twice before actually pulling the plug. So choosing the venue, choosing institutional arbitration or domestic arbitration is something which you should also consider from the point of view of neutralizing the home turf advantage. For now, I leave it at that and then maybe talk more about it as and when my turn comes.
Thank you, Prashash. Atul, you've had in many years of legal experience roles in and observing the process of arbitration. What do you see as some of the benefits and or detriments of some recent developments, including your recent act that came in a few years ago, from the point of view of both a lawyer and also as point of view as a business?
Yeah, thanks, Robert. If you look at the ecosystem that we have had until the amendments and now what we have brought about by way of amendments, I think there is a certain change in how we perceive arbitration. Of course, now you will hear it regularly that this 18 months process has expedited arbitrations. People are now more serious. But I think a larger question, and of course I'll come to the proposed amendments in the Indian Council of Arbitration and the new center which is proposed. But I think the key to making arbitration as a tool, an effective tool, is to further evangelize arbitration in a different context. You see, if you see historically, the arbitration in India has always been dovetailed to the litigations. It's the same bar, it's the same people who are coming in and officiating as arbitrators. So I think we need to go back to the drawing board and evangelize arbitration in a manner where we say that, look, arbitration is something which is not a statutory remedy, but it's a contractual remedy. Once we have recognized that, that's where we'll start working towards a system which is genuinely non-litigious in the conventional sense. And if we look at the amendments which are now proposed, this is our last chance. Unfortunately, Delhi High Court has issued a notice in the challenge to the new ordinance. This is our last chance, and if we don't do it right and create this arbitration center, whether it's that center or some other center, which is of international standards, I believe that we would have missed the bus. The second aspect, of course, is, the amendments. Of course, there's a criticism of the proposed amendments with regard to extending the time for the award. That is where they are suggesting that the time would be 6 months will be given for the purpose of pleadings, and then it will become 12 plus 6. So that, of course, that's a question of debate. Another thing is very good part of the proposed amendment is going to be the confidentiality, which has not been the culture in India. We have not kept the arbitration process as confidential. So now the proposed amendment makes it confidential and except for the award, which will be made public, which again, I mean, I have been KG of international arbitrations, really even relying upon other awards because I think there is a serious issue there. And then, of course, the immunity to arbitrators, that's the another proposal. Well, that's something which we will come to the criminality of it. Probably we'll discuss it in depth. But I think there has to be some mechanism of immunity which has to be available for the discharge of the functions of arbitrators. So I think broadly, this is where I believe we are, and we are at a very, very critical stage of evolving institutional arbitration in the true sense of the word. And I would repeat that if we don't do it right now, I think we'll never be able to do it right.
I would be interested in both of your observations from the Indian perspective in terms of, you've mentioned the question, particularly Prasanna, about a decision as to whether you want an arbitration clause, whether you want your litigation rights, whether the compromise of one or the other is or is not a good thing. What is the prevailing view about whether Indian business in particular favour the litigious process, which we know is slow, time-consuming and may just eat away at people's lives like Chancery House in Dickens, or whether they like a shorter, sharper and more immediate form of resolution in arbitration? And if neither, is there a role that mediation, an alternative dispute resolution, is playing in this dichotomy?
Well, I can narrate a conversation I had with a person to whom I was selling the idea of arbitration. He told me that I don't have to pay the judge, and I just have to engage a lawyer and he'll do everything, whereas arbitrator will fleece me and he will have a per sitting fee, and he will consider the morning sitting as separate and the evening sitting as separate. He'll charge me twice in a day. And at the end of the day, I don't want to trust my destiny, particularly if it is a sole arbitrator. And I would rather have the recourse to appeal through the normal course. So it's a question of lack of confidence in the arbitral system, particularly when there is a sole arbitrator. Most people do not even today agree to a sole arbitrator. They would rather have a tribunal of 3, though of course cost may be quite humongous. Coming to the question that you asked, I find increasingly mediation taking quite a bit of prominence in the Indian scenario. A lot of efforts are being made to promote mediation. Mediation advocacy is on the upswing. And there are a few institutions which have actually pursued mediation and championing the cause of mediation, but it's a very, very long way to go, because at the end of the day, the people who can actually incorporate a mediation clause as a first port of call are the GCs. And the GCs must be convinced that mediation is something that they should look at as a first option before actually going into either litigation or arbitration, because mediation gives them an opportunity to self-adjudicate rather than go for some kind of adjudication by an arbitrator or by a court. So to summarize my point, arbitration is certainly favored by long-term contracts. The short-term contracts do not have an arbitration. Very rarely you have arbitration in short-term contracts. Any concession contract or an infrastructure contract running from 12 to 18 months, it will have an arbitration clause, but short-term contracts don't have. And mediation is taking roots, but it's still a long way to go.
Prasanna, if I can go to Atul, you mentioned 2 points I'd like to raise with you, and that is the question of the cost issue. Are there alternative funding options that are being looked at in the Indian context for running arbitrations? And the second point is, are Indian arbitrators within the domestic jurisdiction here, even if they come into international arbitrations, but they're an Indian arbitrator, is there training up to standard? Are they equal to anywhere in the world? And is the Indian business community and the international community quite happy with it or not?
From a cost perspective, I believe, you see, I mean, let's evaluate an arbitration vis-a-vis a court case. In the present state of our court system, if I go to a court, in a normal, I have, let us say, 2 matters in the court, and I have to wait for, say, 4 hours, 5 hours, realize my matter has not happened, and then I go back, come back 2 days later. In some courts, they blow down the list, it will take days and months. So from that perspective, at least there's one certainty, that when you get into a room, it is only one case which is being handled. That is one, so far as the time is concerned. So you need to understand the cost perspective in that manner. Because if you know that you're paying for a particular thing, which is whether it's arbitrator or the council, you know the thing will happen. And most of the time, I think everybody in this room will vouch for the fact that councils, notwithstanding whether the matter reaches or not, they charge. So because even waiting time, the matter has not happened, but then you have paid. So that's from the cost perspective. From the standards perspective, I believe Indian arbitrators going to international arbitrations, in terms of capability on the merits or the capability to understand the merits and give a fair judgment, understanding whether domestic or international issues, substantially, of course, premised on common law, and even on first principles of civil law, they're outstanding. That would be. The only thing they lack is a discipline, and that's where we need to bring in institutions' discipline. Because if you have an institution in India, then you know that you're subject to this discipline. This is how the form, even the terms of reference are to be decided in this manner. It's more a training issue. They need to get used to an ecosystem of an international arbitration in that sense. They're brilliant people. They can analyze, they can give fantastic awards. The only thing you need to retrain them, and bring them to that level where they understand that, and I put it very bluntly, it's lack of professionalism, with which they are not used domestically.
Prasanna, do you have any comments on those two topics, other than what you've already said?
Well, I do think there are certain advantages in both the systems. Many times people feel very comfortable choosing their own arbitrators as opposed to subjecting themselves to unknown rules of a institutional arbitration, and that is something that people are wary about. And in terms of cost, people actually feel that the cost is so predictable in the case of an institutional arbitration, and you can expect the cost to be within certain range. Whereas in an ad hoc arbitration, it is quite likely that the cost may spiral out of control. And also they say that the party who has deep pockets can actually drag an ad hoc arbitration much longer and frustrate the very good case the other party may have and compel him to come to some settlement. So these are the perceived advantages and disadvantages of the system. And I do agree with him that there are no set rules, but at the same time, the challenge of institutional arbitration is that you should understand the rules before you actually subject yourself to that institution.
Thank you. Out of curiosity for everybody in the room and for the benefit of us, who here in the room has conducted domestic arbitrations in India? Put your hands up. Who in the room has conducted international arbitrations? Same sort of number. Of those who've conducted arbitrations, domestically or internationally, who of you have had a case where allegations of criminal conduct have arisen? Nobody. Oh, there's one there. Is that all? Did anything become public of that case, or did it all remain private? Sorry? Thank you. Gentlemen in India, Prasanna and Atul, if, as a party's advisor and as a lawyer, you're running an arbitration and evidence emerges that you did not know about, but which on reflection appears to constitute criminal offence, criminal conduct, what do you do? Who'd like to take that first?
Okay. Yeah, that's a difficult one. This person has very conveniently left it to me first. No, sorry. Well, I don't have a ready-made answer. But if you see, you look at the kind of fraud or kind of criminality that is involved in the action. Now, even in arbitration, typically you will come across a situation where you will have a criminal act which is sought to be legitimized by one of the parties, right? And there's a claim premised on that, or there's a claim which is being contested on that premise. Now, the first principle, of course, is that it is inter-party. So that, I think, should be the governing principle. And I think the parallel I would draw is the Indian legal position of fraud. Now, the court had taken a view that when it comes to fraud, there's no way the tribunal will have jurisdiction, because that's a question which is to be decided by a regular court. But I think that has been diluted in a recent judgment of Ayyappa Swamy. That's where the Supreme Court has said that if it is a complex fraud, then the tribunal, but mere allegation of fraud would not take away the jurisdiction of the tribunal.
So where is the line drawn between a mere allegation of fraud and, for example, repetitive allegations of conduct in statements with reference to either documents or conversations that becomes, does that make it more substantive and therefore something that falls further away from the tribunal?
No. I would probably clarify that. See, this decision is in the context of appointment of an arbitrator. So the question which arose was whether, if there is a plea of fraud, can you say that the court will not appoint an arbitrator? So in which case the court said that, look, this question is to be decided by the tribunal, number one.
Which question?
Whether it is a case of fraud or not, because I can't do that examination at this stage. So therefore, it is for the tribunal, and the tribunal has the jurisdiction under the Act, Section 16, to decide whether they have the jurisdiction, they don't have the jurisdiction. So, but still, strictly speaking, the question as to whether it is a kind of a fraud or an illegality or a criminality which the tribunal will have the jurisdiction is for the tribunal to decide, number one. Strictly speaking, under the criminal law, if during the course of a hearing an action has come to your knowledge, which could be, this is my view, which could be a criminal act in rem, then surely I believe you would have an obligation to report it. However, if it is an inter-party, because I think the parallel that I'm drawing from the jurisprudence in Indian jurisprudence is that there has also been this move of trying to get a compounding done in criminal cases where it is inter-party. So, for example, the check bouncing cases, which constitutes an offence. Also, some offences which are bailable and in respect of which you can, settle a matter between the parties if it is only a cheating which has led to a financial loss to somebody. Then the courts have said that you can compound the offence if the parties are agreeable. So, it is the nature of the offence. Is it an offence against the state? Is it an offence in rem? Or is it an offence affecting the rights or entitlement of a party? That could probably be the determinant. We don't have a live situation here where anybody has said that it came to your notice as a counsel or as an arbitrator, you were under an obligation to report it to the authorities. That situation has not arisen. But I believe once this provision of the immunity comes in that case, probably at least arbitrators might have a protection. But I'm doubtful if a lawyer would have a protection that it came to your notice that it was criminal action and you should have brought it to the authorities. And of course, with whatever is happening in the country in terms of the abetment and conspiracy, at which even the lawyers have been dragged into, chartered accountants have been dragged into, I believe it will be an area where it is better to err on the right side and at least inform the authorities.
Prasanna, what's your perspective on that approach of leaving, in a sense, the determination of it to the tribunal? And assuming that be right, does that mean that a lawyer, and through the lawyer the parties, have no further obligation to report anything? Or is that safe to adopt?
I can quote two instances which I have come across without naming the parties. One was a private equity investor who was actually enforcing his put option because of certain misrepresentations, and things turned out to be, assured return, and there's some books had been cooked and all that stuff, and financial statements were given, leading him to believe that everything is hunky-dory. And there, the question arose as to whether he can actually invoke the arbitration clause, which would mean accusing the promoter of fraudulent misrepresentation. The counsel actually said, a misrepresentation is a misrepresentation. Why do you want to ride on fraud and create problems for yourself before an arbitrator? So the legal strategy was not to really harp on fraud, and therefore fraud was sidestepped in that case, and the person simply sued him on misrepresentation. So that's one way of sidestepping. It's more a legal strategy because you're not going to get anything out of alleging fraud because it'll only complicate matters. That's number one. In the second instance, in the course of arbitration proceedings, the counterparty produced forged documents to prove that he had, in fact, paid money and gotten receipts, and all the receipts were actually forged. And the question was whether that offense of forgery is something that would preclude the arbitrator from going forward with the case, or whether the claimant is now entitled to actually go to the criminal court and allege forgery. And in that case, the claimant chose to tell the arbitrator that I would like you to stand still till I go to the criminal court and prove that these are forged documents and come and show you. So that was the second instance that I came across where action was contemplated by the claimant to take up the matter before the criminal court.
And how did the arbitrator respond?
Arbitrator actually, he was, the counterparty, of course, objected, but then the arbitrator said that if you want your documents to be admitted, if you want me to take it on record, you need to show that they are genuine. And you can claim, you can call a handwriting expert if you want. If the claimant agrees, we can do that. Or that doesn't absolve you from the actual commission of the crime. One is admissibility, the other is culpability. So the two things are completely different. So the arbitrator took a middle path and said, I'm willing to wait for a few months before my mandate expires. And after that, I will sort of remit my office.
Okay. Thank you. Let's just assume for present purposes that for whatever reason, maybe through a whistleblower or through some anonymous source, disclosure has been made to the authorities of alleged corruption, for example. Bribes have been paid by a large company that's busily suing the Indian government under investor-state treaty and wants a large amount of money because the Indian government didn't pay, and the Indian government's now trying to rely upon this conduct, bribes being received or accepted by its own officers or agents as officials, but paid by the arbitrating party. It's all very messy and they're all desperately trying to keep it quiet, but unfortunately something gets leaked. Maybe tactically or not. And the question then arises as it comes to the attention of the authorities. And Matthew, I'd like to bring you in to sort of get your view about the perspectives of the attitude of authorities in these occasions in your experience as a criminal lawyer, and the sorts of things that you would say or recommend should be at the forefront of the lawyer's thinking when these things arise, because how agents and authorities are going to react and how lawyers and parties need to be ready for it.
I think it's important to recognise that there are different skill sets for different specialisations of lawyer. Civil lawyers have a different mindset in terms of the provision of information to criminal lawyers. There are very different instincts. The instinct of a criminal lawyer is that you say as little as possible and rely as much as possible upon the privilege against self-incrimination. Nobody should convict himself out of their own mouth. Nobody can be compelled to convict themselves out of their own mouth. The next stage on from compelling someone to convict themselves out of their own mouth is torture and to sanction torture. So we have very different perspectives sometimes between criminal practitioners and civil commercial practitioners. So you have this conflict when you get into fraud allegations in civil, because it's not uncommon for there to be concurrent criminal and civil proceedings where there are allegations of fraud. And regularly what happens in the civil courts is you wait until the criminal allegations have been proved where the highest standard of proof, beyond reasonable doubt, and then if there is a conviction, that is wonderful evidence to use in a civil case. I mean, it's an open goal. On a fraud case, if there are overlapping factual issues. In arbitration, traditionally, I would suggest that internationally, many arbitrators view their proceedings as private, as their own little world where it's confidential. What goes on tour stays on tour. Now, that confidence and confidentiality is there for very good reasons in many jurisdictions, because there's sensitive commercial information, or there might be intellectual property, or there might even be dirty secrets. And regularly what happens is one party might try to use those dirty secrets to stop something on a jurisdiction basis or an enforceability basis. This is an illegal contract. We've proved it's an illegal contract, entered into because of a bribe, therefore you can't enforce it. And it depends on the jurisdiction that you're in and where the arbitration is being held and what the seat of arbitration, etc. is, which you're all very familiar with. You then have the situation where the authorities, the investigating authorities, say, we want the information from your private proceedings. And I was party to a conversation with some fairly sophisticated arbitration lawyers 2 years ago where I said, what do you think is going to happen? And they said, it's all private. And I said, it's not. It's not. In many jurisdictions, certainly the UK, Australia, Canada, Hong Kong, Singapore, New Zealand, there are many state authorities that have the right to compel production of documents. So the Financial Conduct Authority in the UK, the Serious Fraud Office can issue something called a Section 2 notice, which says we want you to produce the documents and we want you to answer questions. Those questions that you answer will not be allowed to be used in criminal proceedings against you, but the documents will. So you then put those powers into an arbitration where some very ugly allegations of corruption have surfaced, have got outside the private forum, and the authorities now want the documents. What's the arbitrator going to do? He is a compellable witness. In most jurisdictions, an arbitrator can be compelled to give evidence. The documents aren't subject to any privilege, so they will be liable, in my view, certainly in the United Kingdom, under a Section 2 notice to be produced. And so suddenly, if someone has had the bright idea, let's raise criminality to get out of this contract, actually, you might find that they are in the middle of a very serious criminal allegation where they face personal liabilities. And then that becomes very uncomfortable for the lawyers. You then have all sorts of situations. Is the arbitration becoming a vehicle for the furtherance of a conspiracy? Is it a vehicle for the furtherance of a money laundering scheme? And these are very complex issues which I would suggest need specialists to help provide help. And that's where my suggestion is that the disciplines need to work together and get assistance and provide assistance to each other. But these are very uncomfortable questions, and they're not uncommon. There are cases that I know of where very sophisticated parties have arranged for intermediaries to take bribes, substantial bribes, so that state investment can take place, and then the intermediary, as part of a long game, because they're very good chess players, that intermediary, it was always the intention, will be used to hang out to dry so that they can avoid the contract. I won't say what countries that may have happened in, but that is something that has happened in international arbitration as a long game, very sophisticated, talking big numbers. So these are really quite complex and worrying issues, ethical, legal, criminal. There's all sorts coming in here.
On that note, do we have any questions? Any comments, questions? Is the audience just not falling asleep yet? Nobody? Ah, yes, gentleman there. Do we have a microphone, please? Or not? No? Come and grab this one.
Yeah, so I'm loud. So my question is on when, let's say, in a company, like what if, let's say, if a choice has to be made between misrepresentation and fraud, so which means that the case can fall either ways. And under Companies Act, we have a provision that when the auditors or the management knows that there is a fraud worth more than 1 crore, then you have to inform to SFIO. So how does that thing will work? How does that obligation on, let's say, arbitrator or the lawyer, or it may also go into the knowledge of auditor, because if there's some contingent liabilities have to be recorded because of ongoing proceedings. So how do they balance anonymity with an obligation of informing the fraud to SFIO?
You see, that obligation is standalone. See, if, again, the question is, how do you determine whether it is actually a case of fraud? Now, the fraud comes to fruition. I mean, first of all, whatever is the allegation, it has already happened. So from the perspective of, is there anybody a party to that crime? You will go back and see whether there is a conspiracy. That is, I'm not talking about criminal jurisprudence. I'll come to your question a little later, and I'm saying that for some reason. So the conspiracy can never, it can never be a situation where the crime has happened. It will always precede the crime, right? So the conspiracy will precede the crime. So therefore, there's no allegation there cannot be an allegation if the crime has already happened that anybody, including whether it's auditor or an arbitrator or a counsel, they were part of the conspiracy. So that is one part on the criminal side. So far as the compliance side is concerned, you don't have a determination on that date. So the question is, are you equipped as an auditor? Mere allegation of a fraud or a criminal activity does not mean. I'm, in fact, encountering a case like this where the criminal act had already been done by the board. Somebody else came in subsequently as a CEO 2 years later. As a result of that activity, there was an initiation of income tax proceedings, and that amount was added back to the income because the allegation was that these were siphoning off of funds out of the company. This was never spent for the purpose of the company. So what this gentleman did, obviously in the normal course, was he went to the auditors and he said, look, what do I do? The chartered accountants, whosoever was the consultants, tax side, they said, please file an appeal. So that's a normal course of conduct. Now, he filed an appeal, so he informed the board decided to file an appeal, the appeal was filed, and today it has blown into a big criminal case, and he has been accused as a conspirator. So in that context, there is no determination as of now whether there was a fraud or there was not a fraud. or there was a criminal activity, there was not a criminal activity. So I believe that you have to take that judgment call, and you've got to rely on certain opinions, and then take a call whether they need to inform the SFI or don't need to inform the SFI.
At common law, there is no, unlike the French jurisdictions, there is ordinarily no positive duty for a witness to a crime to report the crime. So the arbitrator is effectively in the position of being a witness. There are statutory obligations, for example, under the Proceeds of Crime Act or money laundering as an example, where there are positive duties to report. But unless they are statutory duties, there's normally in common law jurisdictions no positive duty at common law to report if you are a witness. And then the question is, are you a compellable witness who can be forced to talk about what has been seen and witness summons to court as a witness? So that's perhaps one aspect of it. There's another aspect which I've forgotten what I was going to say. So I'll hand it back over.
I'll just add a couple of points to what Ashish actually asked. If indeed such a situation happens, you must see what kind of company you are talking about. Is it a publicly listed company or a closely held company? Then the complexion of the issue dramatically changes. In the case which I actually mentioned earlier on, the financial statements had been audited, and the audited statements had been furnished to the private equity investor. As you know, auditor's responsibility is to the shareholders, and to make the shareholders believe that the financial statement is in order and the financial affairs have been conducted. And if there are no qualifications, say so. If there are qualifications, mention those qualifications. Now, in this case, the private equity investor, while strategizing a case against the promoter in arbitration, did not allege fraud. He went on a plain misrepresentation. But he actually took a separate action before the disciplinary committee of the Chartered Accountants Institute, alleging that this person has actually misled an investor by giving financial statements which are untrue and not properly audited. So that was a kind of a different course of action that he took, rather than bringing it up as a criminal action.
So my question was, because most of us in the room are general counsels, and few of them could also be acting as the company secretary, and they have some legal obligation when they have some prima facie view whether this could be a fraud or a non-fraud, something to be reported. But I do get your point. We have to take a judgment call as to what should be the next course of action to augment the interest of company as well as your own self-interest.
Thank you. We're coming close to our time, but I'd like to ask each of our speakers just to give their final thoughts in terms of what they would see in their experience as the key 1, 2 or 3 things that you need to take away where these issues of crime arise, and how you as a GC or as an external lawyer should respond. Matthew.
I think the thing that I would suggest you take away is compellability or not. So who should really be investigating crime? It shouldn't be civil parties who are partisan and may or may not provide disclosure which is as full as it should be, as opposed to the state, which has powers to get search warrants, production orders, seize documents, get computers, get evidence. So I would suggest the state is better placed to investigate crime. It's not uncommon for fraud allegations to be raised, but they're not called fraud, so that you don't have to prove to the high standard. So I would say really get specialist advice from, not trying to boost the criminal lawyer fraternity, but from criminal specialists who are used to dealing with criminal allegations where criminal issues arise, would be my recommendation.
Atul, last thoughts?
Yeah, I would draw a distinction between inter-party rights and how it affects either the party. So that's a call which you need to take. But let's take a situation where you know that the arbitration itself is a device to legitimize money laundering, for example. So that is a complete exception to this rule. But I think I agree that, at the end of the day, it's the criminal authorities, the state investigating authorities, which are to investigate criminal offenses. And you don't have, in any case, it's impossible for an arbitral tribunal to go deeper into it. It can only decide the parties' rights inter se. So I agree with that proposition.
Prasanna, last thoughts?
I think much has been said about that. I would like to, my concluding remarks would be about third-party funding of arbitration. I think that's a topic which is gaining quite a bit of prominence. And people used to believe that the Champertian maintenance rules will actually preclude third-party funding in India, but things have dramatically changed. As you know, SPVs are being formed to actually hive off all the debts, and then third-party funding is sought to actually arbitrate. Hindustan Construction Company is one which has done that. So I believe that in the context of third-party funding, if any crime is alleged, it is most unlikely that you will get third-party funding. But if it is a clean as a whistle, a plain and simple dispute, you are most likely to succeed in getting a third-party funding. But that third-party funding itself is a topic for discussion in a full-fledged panel. Hopefully it will happen.
Thank you very much. And ladies and gentlemen, would you please thank me with the panel and their contributions?